an appeal in the matter of H. A. Child.
Yes.
May it please the court, I, together with Mr. Brooke, appear on behalf of the appellant father in this matter. The local authority are represented by Miss Bennell, King's Counsel, and Miss Brown. The mother is represented by Mr. Rowley, King's Counsel, and Mr. Sefton. And the children are represented by Miss Kirby, King's Counsel, and Mr. Jonathan Rustin. My lord, you will know that this concerns a child I, who was born on the 26th of December 2024, and by way of order dated the 4th of September, His Lordship granted permission to appeal the decision made by Mrs Justice Lieven on the 15th of August 2025, whereby she continued the wardship order which had been previously made in respect of the child.
Yes.
And made a return order which would be facilitated by 2 social workers travelling out to Thailand in order to facilitate the return of the child.
Yes.
The facts in this matter are largely, if not wholly, uncontroversial. Perhaps the one area that may present some disagreement is to whether, in fact, I has been abandoned by the parents in Thailand. We submit that it was the intention of the parents to return to Thailand following their return to England on the 12th of June 2025, and it was only their arrest, subsequent bail conditions, and thereafter the passport orders which have prevented their return. And it appears to us that there is some recognition of that factual proposition contained within Her Ladyship's judgment. May I first of all invite you to consider the terms of the wardship order which was made by the learned judge.
Can I just deal with timing? We will rise as normal at 1 o'clock, but we won't be able to start again until 2:15. So the submissions will have to, I don't know whether you've agreed about time or anything like that. Have you divided the time between you?
We did have a preliminary discussion. We anticipated that we would be no longer than 40 minutes.
Right. Okay.
I did not hear what the others said, but I would imagine.
That's all Mr. Early indicated. So yes, okay, thank you. Yes. So the order.
Yes, which is found in the core bundle electronic 6.
Same page on for reduce
Grateful. 186, 187, and then at 188 at recital F is what was contained in the social work statement which was filed prior to the hearing before the hearing in August as to the local authority's clear intention to issue care proceedings upon the child's return to the jurisdiction. G sets out what I've already indicated to the court as to the practical arrangements for implementing the return.
Yes.
And then in the body of the return order itself, one will see at paragraph 8 as to how the proceedings were to be progressed by way of court hearing.
Yes.
That it would be listed for consideration in the family division within 72 hours of the child's return. May we present this as for the court's consideration as to whether this order was a contravention of section 100 subsection 2 which in our submission was identified by his lordship in the decision of Re M and at paragraphs 136 and 137, and may invite you to consider that, which is in the authorities bundle at 139.
Can I just get back? It was agreed below, and reading the submissions to this court, it seems to be agreed that the court had jurisdiction to make the order which you're showing us, which was made.
Yes, there was agreement across the board. It was
Yes. And so the only question was whether or not it was an appropriate or proper exercise of the court's jurisdiction, and whether there are flaws or errors in the judge's decision or judgment which undermine her ultimate decision to exercise that jurisdiction.
Yes,
Is that
indeed.
right?
That encapsulates the arguments that were placed before her ladyship.
Yes. Okay. Sorry. Where were you taking us?
136 and 137 at authorities bundle page 139.
Sorry, you're going to have to tell me again. What page?
139.
Thank you. Yes.
And may I pick it up at 4 lines from the bottom by G, an order providing for her care needed to be made before A arrived here because the necessary arrangements needed to be in place. Such an order would either have conflicted with the provisions of the 1986 Act, or if it gave care to a local authority, would have conflicted with section 100 of the 1989 Act.
Were the terms of the order in Riem identical to those you've taken us to on page 189?
Your Lordship, I don't think they
I'm
were.
looking at the previous paragraph 135, which seems to which my Lord quoted from the order in the last lines of 135.
Yes.
Those words don't appear, do they, in the order in this case?
No, they don't, but you do have a recital that the local authority are going to be issuing section 31 proceedings upon the child's return,
Yes.
which, just as the purpose was stated in the cited authority in the order, the specific purpose and context, we say, is set out in that order.
Well, it might be, but you were talking about jurisdiction, and saying in an order or recital in an order that on the child's arrival in this jurisdiction we will commence proceedings is perfectly legitimate, isn't it, jurisdiction-wise?
Well, where that goes to is the wider consideration as to how the jurisdiction and whether the jurisdiction should be exercised.
I mean, as I said a moment ago, 2 points. One, is there jurisdiction? And it's agreed there is jurisdiction. Two, was it appropriate for that jurisdiction to be exercised in this case? And I thought you were taking us to section 100 for the purposes of perhaps revisiting. It was agreed there was jurisdiction.
No,
Right.
no, that's not a matter
Okay.
which was raised, and I'll be quite clear about
Okay,
that.
thank you. So what is the relevance of paragraph 136?
Well, 136, it did cross our mind as to whether in fact an order which in essence made continued I's wardship and then provided for her placement in local authority foster care on her return was in essence trying to achieve something which is prohibited by section 102. But allied to that is 137, which sets out even if no such order was made, the clear purpose of the order was to enable the court to undertake a welfare inquiry for the purposes of deciding who should care for A and to vest its court jurisdiction to undertake the exercise by procuring A's presence in England. And what we're saying is that there is similarities between that position and what was being set out and being achieved by the order of Mrs Justice Lieven. That was to secure the child's return to this jurisdiction so as to enable the local authority to issue public law proceedings in respect of the child.
And the judge was very aware of that, including because that is expressly made clear in the order.
Yes.
So it was a factor the judge clearly took into account.
Yes, but we would say that if one faithfully adheres to what is set out in Re M and then followed in Re D by Ms Justice Henke, that there needs to be close consideration as to whether the context of a return order with a view to issuing public law proceedings is permissible.
Are you saying it is not ever permissible?
Well, lady, I note that in certainly the local authorities' skeleton argument, they refer to an exchange between myself and her ladyship. Of course, reflected upon that, whether that concession should be made, and that's not me being duplicitous by in any shape or form. It's me reflecting again. My answer to that would be there is a paucity of authority. Reedy is the only one that we've been able to find which comes close to addressing the issue of public law applications. And in the authorities we've been placed before you, there has been return orders coupled with the making of wardship orders.
Sorry, presumably the wardship order came first.
The wardship order comes first and thereafter return order. Whereas in this scenario, the return order comes first and thereafter.
No, sorry, I may have misunderstood. The child is currently a ward of court.
Lady, sorry, I didn't hear you.
The child is surely currently a ward of court.
She's a ward of court.
Yes.
But the return order was made, we say, in order to enable the local authority to issue public law proceedings.
Well, if we look at what we all said at the end of 136, is it your case that this order conflicted with the provisions of the 86 Act, or gave care to the local authority and therefore conflicted with Section 100? Which do you say? Or do you say, I think you say one or the other, I'm not quite clear which.
Well, if it conflicted with Section 102, then that probably obviates the need to consider whether it conflicts with the 1986 Act.
Well, is it your case that this order, Mrs Justice Lieven's order, gave care to the local authority, to use the Lord's phrase, and therefore conflicted with Section 100?
Yes.
Which provision particularly do you say was amounted to the giving of care to the local authority?
The social workers travelling to Thailand in order to return a child and then place the child in foster care pending the matter being reconsidered by the court. I think it was within 72 hours of the return being effected. Well, may I now move on to where we see the land lies and the legal position following the authorities of A, Re-B and Re-M, because there appears from the scouting arguments, particularly that filed on behalf of the child, that there is significant debate as to what was being said in Re-M and its interpretation of the Supreme Court authority in Re-B. That's how we read it.
Would you forgive me if I just go back to your last point about section 100? My colleagues will forgive me too. If somebody else other than a local authority social worker had been deputed to collect the child from Thailand, would there be any question of section 100, subsection 2 being infringed?
Yes, because on return, if there was a placement in foster care,
Where does it refer to foster care?
it doesn't explicitly refer to it in the order, but it is endorsing what the local authority has set out in its statement of the 17th of July, that upon the return, the most likely avenue would be I would be placed in foster care.
But once the child is here, the court has its statutory jurisdiction. The court can make any order, interim care order, or whatever, once the child is here.
But it's the
So immediately on landing. I mean, could the court not make an order predicated on the child's arrival? So saying, upon the child's arrival in this jurisdiction, this order will have effect. Would there be anything wrong with that, jurisdiction-wise?
if it was a section 31 order or an interim care order,
Yes.
then obviously there would have to be the application. But even in those circumstances, that is even more explicit as to the context of the return order.
No, I understand that. We're talking. Your at the moment, your submission is that the order runs across section 102. Is that right?
Yes.
And what my lord was suggesting, that if somebody else other than the social workers was authorised to bring the child back, and I'm putting another alternative, was there could be a hearing in expectation of a child's arrival back in England. And the court will often make orders which have effect once the jurisdiction arises. In other words, the parties are required to commence proceedings, for example, and upon the commencement of the proceedings, the order will have effect. And what I'm asking at the moment is that would there be anything jurisdictionally wrong with the court having a hearing, making an order, upon the child's return to England and upon the local authority undertaking to commence proceedings upon the child's return, these provisions will have effect, interim care order, for example?
Well, sorry if I don't answer, not answering your question clearly, but probably the main driver is what is addressed in the skeletons, is that in that context, that is a way of avoiding the habitual residence presence requirement in order to issue section 31 proceedings, which was identified by...
But it's not a way of avoiding it, it's a way of addressing it in a manner which doesn't conflict strictly with the terms of the jurisdictional framework. I mean, is your case based solely on the cutting across the statutory scheme? Is that the foundation of your submissions in support of this appeal?
That is the principal and primary argument that we place, which we've addressed in our skeleton argument, that one has to look at the reality of the order, the nature of the order which is being sought, and the context.
And as my lady asked, if the conclusion is reached that the order is being structured in such a way as to so as to avoid the limitations of the statutory scheme, is that an absolute bar or is it just a factor?
Well, the authorities quite clearly say it's a factor. And we would have to abide as to what has been repeatedly said as to it then is a factor to be considered as to how it should be exercised rather than
Yes.
whether there is a legal basis in the first place.
The point of section 100 was to head off the practice which had arisen prior to the passing of the children being placed in care through wardship proceedings, through the inherent jurisdiction. Prior to the Children Act, there were, I think, over a dozen ways in which children could be put in the care of a local authority. Wardship having become in the 1980s the fashionable way of doing it. And the whole point of section 100 is to stop that, stop children being placed in the care of the local authority. For my part, without checking the authorities on this, I'm not persuaded that it, at the moment, that it precludes the local authority from using the inherent jurisdiction in a way to protect the child prior to the issue of care proceedings, in the way in which my Lord has discussed with you.
Well, I don't wish to exhaust my time as to whether there was a contravention of section 102.
Well, you opened that up.
I did, and I have to concede that, that's of my own making. But it was something that I wished to ventilate by looking at 136 or 137.
Right, thank you.
But as I said, the appeal has been placed on the basis of what is the position in terms of public law applications, and looking at the context which has been set out in Riem and by Miss Justice Henke and Reedy. So, if I may turn to my primary argument, and you will note in the Guardian skeleton argument that there are a number of authorities at paragraph 65 of that document, which is page 95 of the core bundle, which makes reference to those authorities contemplating that the subject child or children would be placed in local authority care. And may I deal with this quickly? It will be 2008 authority of...
Sorry, which paragraph are you?
Paragraph
66.
66.
56 or 66?
66.
66. Thank you. Yes, got it. Yes. Yes.
Yes, the first authority at the foot of 95,
Yes.
we say that that authority did not deal with the contemplation of placement in local authority care. In fact, the child entered the country to Scotland, so the wardship was discharged on the basis that the Scottish courts then became seized. The next authority, that of Mr Justice Munley, we agree it's right to say that care proceedings were contemplated, but there was no express, or it wasn't expressly stated anyway, that that's what the local authority were going to do, to immediately remove the subject child into foster care. ND and K, decision of Mr Justice Hayden. That was an abduction private law application by mother for a return of a 4-year-old child from Nigeria. There was no local authority in the proceedings or judgment, and in fact it was Mr Justice Hayden wished to explore sending the child directly to France and to be with his mother rather than England. And then finally the decision of Mr Justice MacDonald. The application, as the court is aware, was made by the child to be brought here to escape his mother. He was nearly 17. He wished to return from Somalia and indicated that he would like to be accommodated pursuant to section 20 subsection 3. And there was no application by the local authority for section 31 proceedings. We have failed to identify any other authority where the interrelationship between section 31 applications and the use of return orders pursuant to inherent jurisdiction has been engaged. The closest we say is that of Miss Justice Henke, which was dealing with setting aside orders which had previously been made for a return of children from Iraq. May I now deal with or address what was said in Re B about nationality-based jurisdiction, and to what extent they addressed the crucial issue which we say was addressed by your lordship in considerable detail in Re M and requires further elucidation. And we begin first of all with the observations of Lord Wilson. That is paragraph 53 of the judgment.
Yes.
And we say, and by reference to the matter set out below G, the dilemma which the court faces in this
Sorry, can you, what, G?
96, it's the authority bundles 96.
Yeah. Yes.
To my mind, the most problematic question arises, and it continues, ends, should the interests of the child prevail, and indeed would Parliament have so intended. And whilst I am at this passage of the decision, in the previous paragraph, paragraph 52, we say then, reference to A and A, that the 1986 Act did not preclude a bare return order to this jurisdiction. And that bare return order is then referred to in by your lordship in Re M. It's referred to by Miss Justice Henke in Re D, where she in particular drew a distinction between previous orders made by Mr Justice Francis, which was a return order, a bare return order, but one then which offended the principles of the 1986 Act when one looked at the intention of the local authority upon the child's return for jurisdiction, which was set out in the pre-birth risk assessment. Then at paragraph 58, if I may invite you then to consider that, which is the speech of
Just looking at what Lord Wilson said in paragraph 53, talking about factors, the question would be whether in such circumstances an order for her return would improperly, so he uses the word improperly, or contrasting with that, whether the circumstances were such that the interests of the child should prevail. Is that a fair way of just analysing the factor, what you're looking at? Does it improperly subvert, or should the interests of the child prevail? And I'm emphasising the use of this word improperly.
there is, if one looked at it simply as that by reference to the interests of the child, whether they should prevail, there is a danger of offending the proposition and the argument that the court's inherent jurisdiction is versatile, but not without limits. Of course, the interests of the child and the fact that return orders are protective in nature will be engaged. But then, whilst not only considering whether the local authority should be provided with a roving child protection mandate, one would also, in our respectful submission, and I'm sorry to digress at this stage, consider whether the child would be beyond judicial oversight, which is a matter which is referred to in the authorities and is specifically addressed by Mr Justice MacDonald in the authority which delivered, which came out earlier this year. So it's not simply looking at that characteristic, one set aside the others the court has identified. There are other facets which need to be considered. And one has to keenly consider the prohibition on Section 31 applications being issued without there being habitual residence or presence.
Yes, very well. So you were taking us to
58, which is a speech of Baroness Hale.
And Lord Tilson, I think.
Yes, and Lord Tilson, my apologies. That is page 98. Where it's set up that because of the conclusion on the issue of habitual residence, it's unnecessary to reach a decision on the hypothetical question whether it would have been right for the court to exercise a jurisdiction founded on B's nationality. And then we say that the closest that this argument is addressed into relationship with the 1986 Act is addressed by Lord Sumption.
So Lord Sumption is both obiter and dissenting.
Yes.
But the lower level of obiter observations, you might
Yes.
say.
That is acknowledged, but then there is a reference, I'm not going to describe it as a veiled criticism, as to how that minority dissenting dicta is then treated by his lordship in Riem.
I quite agree. There is a question. Yes.
And in our respectful submission, his lordship in Riem was quite entitled to consider what is set out by Lord Sumption at paragraphs 81, 82, '85 in his examination of the law in Riem. And at 83, despite me saying that he is the person who comes the closest to considering 1986 Act and the use of inherent jurisdiction, he does set out that a dissenting judgment is not the place for a detailed examination of the ambit of the inherent jurisdiction. There was such an examination required in order to determine its appeal. So we say it was not conclusively addressed, and then his lordship takes up the baton, and as we say, provides elucidation in Riem, and may we invite you to consider his lordship's observations in Riem.
Yes.
And the first reference is at 120 of the authority manual. Paragraph 43. And the last sentence, which I have repeatedly been saying to the court about context. And if one looks at paragraph 89, this may address a question which was posed of me some moments ago. The important question is therefore, what is the test or guide which a court should use when deciding whether it is appropriate to exercise its jurisdiction? It is self-evident that it will ultimately depend on the circumstances of the case and on the nature of the order being sought.
Yes.
Could I invite you to consider paragraphs 118 and 121 of Riem, which are pages 136 and 137, which picks up on what I was alluding to as the veiled criticism, which is contained in the Scouting Argument of the Guardian, whether in fact the same arguments are being rehearsed, and I say that respectfully, by my learned friends retired. Because the reason why I say that Miss Kirby herself submitted that the context of the judge's decision was important. She frankly acknowledged that his order had been designed to give this court jurisdiction to undertake a welfare inquiry by requiring the child to be brought to England. However, she submitted that this was a limited exercise of inherent jurisdiction because the judge had only been deciding whether jurisdiction should be exercised so as to enable the court in England to carry out a full welfare inquiry. And then (121), which is on the following page, reference to the judge not being addressed on the effect of the 1986 Act, but Ms Kirby submitted that the judge's order did not conflict with the provisions of that Act because it was a return order as had been made in A&A. She further submitted that the purposes of the order, namely to give this court welfare jurisdiction to establish A's wishes and feelings, also did not conflict with the 1986 Act. So we say that there was a recognition in that matter as to context being important. And also, what we say is a difference between bare return orders and orders which conflict with the 1986 Act provisions. And we say that the court, in this case, made a return order, which was not a bare return order.
I think the word conflict is quite tricky because either an order does conflict or it doesn't. Either you have jurisdiction to make it or you don't. So how can an order which the court has jurisdiction to make conflict with a jurisdictional framework?
Of course, the jurisdictional framework doesn't specifically address public law applications, but you would see in the analysis as to how public law applications should be treated in a similar manner, based on habitual residence and presence. We did have this debate with the early judge in August as to, well, if it cuts across the statutory scheme, it cuts across the statutory scheme, and it shouldn't be a case of in what circumstances it does so.
Do you understand the phrase cut across the statutory scheme to mean? What's your submission as to what it means?
Trying to achieve something which is prohibited by a statutory instrument.
But that's another way of saying there's no jurisdiction.
Indeed, my lady.
You've accepted there is jurisdiction, have you not?
Yes, and for me to say there was no jurisdiction would be having to persuade you that all the line of authorities which have been identified in REM are incorrect, where they say that there is a jurisdiction.
But it's not only that, we've got Supreme Court evidence that there is jurisdiction, have we not?
Where we find ourselves is that the authorities say that there is jurisdiction. It's how that jurisdiction should be exercised, and one has to look at the context.
Indeed, but once you have jurisdiction, you're effectively trying to say, as I understand it, there is jurisdiction, but nonetheless there is a bright line.
Yes.
Where you should, frankly, never, I think you would rather have not made the concession you made below. You should never exercise the jurisdiction if what is in contemplation is care proceedings.
Yes,
That's what you're saying.
that is what we are saying, and that is entirely consistent, which is set out by Mrs Justice Henke, which we say takes fully into account what was said in REM.
Well, yes, REM said there is no bright line. As my lady says, looking at A&A, and indeed the majority over obiter observations in RE-B, they also don't identify a bright line. So how does your case meet those points? As my lady has said, that there is effectively a bright line. The court should never exercise jurisdiction if care proceedings are in contemplation or in expectation
Well, there was a clear bright line in Reedy, and there's a clear bright line in the instant case as to what the return order was seeking to achieve. And we have referred to the non-existent, not exhaustive list of cases where return orders have been made.
But can I just test that? I mean, you agree this at its highest is just a factor.
It is a factor, but an important factor.
That may be, may not be, but it's you're seeking to turn it into a determinative factor. And okay, in some cases, a factor might be the factor which justifies or should be given the most weight and may in one or other sense be determinative. But that comes down to the facts of the case.
It does. But may I present an argument which is probably contrary to the proposition that I've been making.
Right.
And if one considered the position in the authority I referred to of Mr. Justice MacDonald, where he determined that there was no operative child protection system in Somalia, would in those circumstances that prevent a court from permitting a local authority to seek a return order with a view to issuing Section 31 proceedings in those circumstances? The court would probably be very slow to permit a situation where a child to which the inherent jurisdiction applies would be left without any form of protection. So that probably brings me to the position that, yes, it is a factor, a very important factor, but you then have to marry it up with what I've referred to some moments ago, was a consideration as to, was this child beyond all judicial oversight in a jurisdiction where the child currently finds himself or herself in.
You're still saying that it is a bright line.
There's a bright line in this case.
You're saying that so I'm clear, the bright line is that you can't exercise jurisdiction in contemplation of the local authority issuing care proceedings as soon as the child's back.
That is a bright line, we would say.
But I think you offer a caveat by reference to the Somalian case you just mentioned, which is there might be an exception to that if the child would be beyond all forms of protection. Have I understood you correctly?
Yes, it's me trying to engage with the court as to, well, there are a range of factors which we're trying to decipher from all the authorities. There is a lack of guidance in respect of public law applications, hence the reason why we find ourselves here.
Apologies if you didn't take us to it, if you did take it to us earlier and I missed it, but in Grade B, there are some, I'm going to your Somalian point, there are some factors listed at paragraph 59, sorry, page 98, covering that position where there is another jurisdiction that may be able to protect the child. I think that's in the judgment of Baroness Hell and Lord Toulson, but I think Lord Wilson effectively agrees with it earlier. That's not limited to the Somalian case, is it?
No. However, paragraph 59 needs to be read in the context of the observations in Riem as to these three factors.
Well, hang on. Well, we can have a debate as between the Supreme Court and the Court of Appeal, but this is significant guidance from the Supreme Court, isn't it?
Yes, but the passages that I took the court to were that the interrelationship with the 1986 Act weren't at the forefront of its mind. It wasn't addressed in anywhere near as great a detail as His Lordship in Riem.
And I do understand that, but I just wouldn't. It seems to me that that passage is relevant and needs to be taken into account.
Those are put forward as reasons for caution, as they say, when deciding whether to exercise the jurisdiction.
Yes.
That they're not put forward as limiting the scope of the jurisdiction. In other words, they're not, as I see it, coming close to supporting your submission that in some circumstances the court should never exercise. So if the court is contemplating care proceedings. That submission is a very, very long way from using caution when deciding whether to exercise.
Well, I accept what is said in relation to that, but to use whether there's a bright line, well, there clearly is a bright line in Re and Riem because the purpose and the context is.
Were there any other passages you wanted to show us in Riem?
For my part, I wondered if you want to say anything about paragraph 107, which is where one of the passages where there is a reference to the statutory scheme. But there may not be anything you want to say about 107. I just wondered whether there was.
Well, of course, I would acknowledge in support of arguments that there is a substantive threshold in such applications, and that substantive threshold is not crossed if the local authority is looking to achieve what it wouldn't otherwise be able to achieve due to the fact the child not being outside, due to the child being outside of a jurisdiction.
How does that submission fit with paragraph 108, which proposes a test, namely that the jurisdiction requires sufficiently compelling circumstances?
Well, I'd refer once again to paragraph 89, which is 131. Important questions: what is the test of a guide? It's not just circumstances of a case, it's of the nature of the order being sought. Has to be considered as well.
Right, thank you. Are you going to take us to Re D?
Yes, I am, because albeit it's a High Court decision, in our respectful submission, this is has a greater similarity with the incident case.
Yes. Can you just help us briefly as to the facts of that case?
In essence, in previous proceedings prior to the ones that came before Mr Justice Francis and Mr Justice Henke and Honour Judge Lloyd, there were previous proceedings in which Mr Justice Moore found that the father had inflicted fatal injuries upon a child. The family then, not the father, the family then found themselves in Iraq. The child was born, there was a pre-birth assessment which was undertaken in respect of the unborn child in September 2019, which recommended that there should be care proceedings issued. The matter then comes before Mr Justice Francis in September 2019. He makes a return order, and it is clear that when that application was made, the pre-birth assessment accompanied the application. Thereafter, those orders were repeated by the judges I referred to, which then led to an appeal, which was unsuccessful because it should be a set-aside application, and the set-aside application came before Mr Justice Henke, who considered whether in fact those orders were permissible in the first place.
And by then the child had been living in Iraq for 4 years.
Yes.
When I was 4 years old. Yes.
There is reference in both the Skeleton arguments of my learned friends that on the particular facts of that case, that Mr Justice Henke declined to exercise a jurisdiction. We say respectfully that that is an oversimplification of the decision, because if I can invite you to consider paragraph 94 of Her Ladyship's judgment, which is 202 in the bundle.
Yes.
Sorry, it's paragraph 91. I might have referred you to the wrong paragraph, where Her Ladyship refers to the circumstances at the time that the court was seized.
Yes.
She then sets out the significant risk factors which have been found by Mr Justice Moore.
Yes.
And then she concludes by saying, standing back and looking at circumstances at the time this court was seized, they were very grave indeed. And then, so there was an acknowledgement on her part that we say that there were significant risks presented to this child in Iraq, probably of a greater magnitude than those which are present in the instant case. But we say where she draws a line and determines that the return order should be set aside are at paragraphs 92
96.
sorry, 95 and 96. By reference to Lord Sumption and Lordship, the context, the real object in exercising it, which we say is another consideration which a court needs to consider. And
So it does look as though the factor, well, the only factors she mentions in 95 is that the order is cut across the statutory scheme, and then is, if you look at 96, is it the bit that begins, in my judgment, the orders in this case went too far?
My lord, yes. We say that she was acknowledging that there were grave risks. That was not the reason why she did not determine, it's not the reason why she set aside the return orders. The reason she did so, we say, is set out at 96.
Yes.
Last two or three sentences of 96, I think, are her reasoning. Because the purpose for exercise jurisdiction was so that the local authority could exercise its statutory duty and issue public law proceedings. And Mrs Justice Lieven said that was a use of the statutory scheme which cuts across, a use of the inherent jurisdiction which cut across the statutory scheme in this case and its jurisdictional boundaries. I think, am I right? That is the ratio of hers.
That is the ratio. And that is a ratio that she has drawn, which I've indicated, from Lord Sumption and
Yes.
court in Riem.
It's interesting, isn't it, that she adds those words and its jurisdictional boundaries. So that, is she saying there that there wasn't jurisdiction to do it?
No, because that would be inconsistent with what she says at where she says that there is jurisdiction, but whether it cuts across the statutory scheme goes to how it should be exercised. So it may on the face of it appear to be inconsistent, but that's what she clearly says in the other paragraphs of her judgment.
So you, in one sense, are inviting us to consider whether this decision was right or wrong?
I think that's if Her Ladyship's dicta is accepted as correct, then we say that it applies in this case. If she is wrong, that context, reality are not important features. Then it probably follows that she was wrong. And she considers her reasoning, or continues her reasoning in paragraph 97. And then on to 2003, again, reference to a reality of the situation.
Yes.
And further support, we say, in support of the ratio of Her Ladyship, rather than the facts as they presented on the grounds being the material factor. You'll see, given that as a matter of fact, the events since the 25th of September, when the risk assessment was undertaken, can only have aggravated the risk. The reality was the assessment would be a precursor to public law. So it's further acknowledgement that the situation was equally perilous to the child in Iraq. But it was the reality and the context of the application which led her, as you will see at the conclusion of paragraph 97.
What I'm struggling with is that if the circumstances justifying the use of the exercise of the inherent jurisdiction are sufficiently compelling, how does the fact that the order is being used in order to protect the child by bringing the child back to this jurisdiction so that care proceedings can be started conflict with that, if the circumstances are sufficiently compelling? In other words, sorry to interrupt your thoughts, but it's it's using the word I used in paragraph 61, reality of what was being proposed, and that was simply saying the court will need to consider whether the order is in reality an order which conflicts with. It wasn't looking at the purpose, it was the reality of the order, and that's become sort of converted into a precursor to public law orders being somehow prohibited. And I don't see how that fits with what was said in NA about the circumstances in which the jurisdiction arises, or indeed in rem as to the test, if you adopt the words sufficiently compelling. How do you submit that those two fit together?
I've identified in Rian that it's not circumstances.
It's a factor.
Yes, it's a fact.
But it seems that Mrs. Justice Henke elevates it to a bar. Or am I misreading what she's saying? Am I being unfair?
I think you may be, may I say it, unfair
Right.
to her ladyship. I think she would say that no, I wasn't elevating it to a bar.
Okay.
But where
Thank
the
you.
intention is clear in a case, then that is an important consideration. And one knows that from the second limb of our argument that we do not say that you look standing back that the circumstances were sufficiently compelling in this case to make a return order, which is the precursor to public law proceedings. And there are reasons why public law applications are made on the basis of habitual residence or presence. Even if one looks at it in this jurisdiction, what would happen? Well, the local authority would inform the neighbouring local authority of which the family were of its concerns, disclosure of documents, and then it would be for that local authority to determine whether it's going to issue public law proceedings. In this case, because we say, and we've referred to it by reference to the McDonald J decision, that this is not a situation in Thailand where there is no child protection system in place. One knows that it's operating, one knows that there's been visits to the child, that practically what the local authority should do is the referral should be made to the Thai authorities, which they did, with the relevant documentation setting out the litany of concerns. And then it's a matter for the Thai authorities to take what action as they see fit.
Thai authorities seem to be have written in anticipation of the relevant authorities in this jurisdiction arranging for the child to be returned to England and Wales. That's their position at the moment. Have I misread what's been said?
That is their position. That continues to be their position. But we say that that's not an uncommon concept which comes before this court in Hague applications where there's a transfer in request, where the jurisdiction requesting that this jurisdiction assumes control is working on the basis that that transfer will be made.
Yes, and that's, I mean, if the 96 Convention applied, that could almost be treated as though it was a request for this court to assume jurisdiction.
Lord, it would.
And it would be difficult to say this court was not better placed to make welfare decisions.
Indeed.
Can I just go back to the point about the a precursor to public law orders? If the application is being made by a local authority and the jurisdiction is to be exercised when there are compelling circumstances, it might be thought that in many, if not most, of those sort of situations, it would be a precursor to public law proceedings, or certainly assessments that might lead to. So if you prohibit that, you are placing a very wide-ranging limitation on the circumstances in which the jurisdiction could be exercised. You see what I mean? I mean, Miss Justice Henke recognised it was somewhat counterintuitive, and I can see why. Because if the test is compelling circumstances, but somehow, however compelling they are, if it's the order is being sought as a precursor to public law orders, you can't use it, then you're prohibiting its use perhaps in the very circumstances where it needs to be exercised.
Well, I see the strength for that argument, leaving the child effectively without a remedy or without protection. But as I've referred to, looking at the whole circumstances of a particular case, an important feature, we say, is the child protection system which is present in that jurisdiction.
So what would you envisage happening? You'd envisage all the court's orders being set aside, and the parents being able to, if they were given a visa to, we don't know whether they would be given a visa given the circumstances, to go to Thailand. What would happen if they weren't given a visa to go to Thailand? I'm just postulating a different set of circumstances.
Well,
would it still be an inappropriate use of the court's powers because it would be a precursor to public law proceedings?
Lord, we have to be realistic about this. It's going to be an unattractive proposition to leave a child without anyone affected or carrying out parental responsibility for a child in a foreign jurisdiction, a child of that age or
Yes.
any age.
Yes.
So we are realistic about that. But to return to the court's question, the parents, I am told, would travel out to Thailand on the 90-day visa, which they would be entitled to. The wardship order would have to be discharged, the return order obviously would be discharged, and the passport orders would be discharged. And then it would be a matter then for the local authority through the Foreign and Commonwealth Office to communicate the continuing concerns it has in respect of I, and then it's a matter for the Thai authorities to continue to undertake their checks and their visits as they see fit. And I return to what is said, that it may seem counterintuitive from a child protection standpoint, but there is a reason why there is a lack or an absence of return orders being made in the context of public law applications being made upon a return to the jurisdiction.
Mrs Justice Lieven summarised, having considered what Mrs Justice Henke had said in reading, paragraph 55 summarised the principles very succinctly, and she characterised the point which Mrs Justice Henke focused on at Roman 3, 55d3. In other words, when in determining whether to exercise the jurisdiction, the court must have close regard to the existence of protective measures in the other country, factual circumstances of the case, and the relationship with the Family Law Act 86 and the potential to illegitimately avoid its effect.
In our skeleton argument, in order to paragraph 42, we address that,
Yeah.
which is 52 of the core bundle. And whilst we don't take issue with the matters which are set out at A, B, C, D, Roman numeral 1 and 2, we submit that there needs to be further particularisation and consideration of the matter set out at Roman numeral D3, which is the reasoning of, we say, his lordship in Re M and that of Mrs Justice Henke in Re D. What is the purpose? What is the context? Which has to be.
And it could be that the phrase the statutory scheme should be seen as a looser phrase than jurisdictional, simply the jurisdictional rule. And it could be thought to mean the general principle that children, cases about children should be determined in the country of their habitual residence, which is a statutory scheme. But the jurisdiction clearly exists, as you've all conceded. The question of whether it should be exercised should be determined according to the factors which Mrs Justice Lieven and others have identified. One of which is the potential to undermine the broad principle of habitual residence being the determinative fact.
And that is a matter which is cited frequently in the authorities as to, well, you have these conventions which are premised on habitual residence. That is the way that matters should be approached, and there should be some consideration of that, we submit, when considering whether the inherent jurisdiction should be exercised in the context of a local authority issuing an application for Section 31 proceedings. Which comes back to, or allied to what we say about what should happen on the ground in Thailand.
Yes, thank you.
Is there any other matter which?
No, thank you very much. What? Yes, Mr. Rowley.
My lords, my lady, we substantially align ourselves with the submissions made on the appellant's behalf. A couple of caveats. One, we say that the order made in this case by Justice Lieven did not itself give care to the local authority. We don't say, therefore, that it was foursquare with the circumstances of the first instance judge's order in paragraph 136 of Re M, as I think was submitted earlier. But of course, in the following paragraph, and we're not going to travel the same ground, I hope, at any great length, but in the following paragraph, this court, Honourable Court, I should say, alludes to the purpose of the order that was made in that case, which was to enable the English court to undertake a welfare inquiry. And we say that's the crossover point, similarity here, because though the bare order by Mrs Justice Lieven did not itself give care to the local authority, didn't defend Section 100 of the 1989 Act, there can be no question but that the driving force behind it was to bring Hyde back in order to then conduct a welfare inquiry. The judge effectively conducting a form of that herself at that hearing. We would also, I think, have to concede that the bright line is not represented by whether or not a local authority has care proceedings in contemplation. And as my Lord Justice Moylan observed, almost by definition, if a local authority, not always, but many cases, if a local authority is seeking to invoke the inherent jurisdiction, it is most likely to be doing so in circumstances where, at the very least, there are reasonable grounds for believing that the Section 31 subsection 2 of the 1989 Act and criteria are
Can't apply to it. Can't be granted leave to exercise the jurisdiction, can it? Without there being evidence of significant Section 104.
So that can't.
Doesn't marry. Yes.
Forgive me.
Doesn't marry.
No. Otherwise, we make the following submissions as to the substantive appeal. So, firstly, as is agreed, across the board, the jurisdiction to order the return of a British child to this country under the inherent jurisdiction exists, and there could be no demurral from that, because of course that is established by A&A, by the Supreme Court. Second, all that was said in Re B, as has already been discussed and was identified by this Honourable Court in Re M, both by the majority and the minority, were overturned concerning the circumstances in which the exercise of the jurisdiction may be proper. So they are, to varying degrees, as my Lord Justice Moylan has identified, persuasive but not binding. Third, the decision of this court in Re M as to the test or guidance for the exercise of the jurisdiction was binding on Mrs Justice Lieven, as she acknowledged. Fourth, a portion, substantial portion, arguably, of the argument made by Miss Kirby in support of the judge appears to be either a re-arguing or a critique at the very best of this court's reasoning in Re M. Can I invite you to consider that, please, at so authorities bundle, page 94.
Excuse
Sorry,
me.
no, it isn't. It's core bundle, page 94. So, when making comments about the appellant's argument, learned friends go on to say, 6 lines, to give me down. Court of Appeal in Re M sought to clarify the test and arguably to restrict the use of the parents' patriae jurisdiction further than had been done by the Supreme Court. Paragraph 64, the learned judge rightly, the judge rightly did not follow any overt parts of Lord Justice Moylan's judgment in Re M that appeared to contradict the binding authority of the Supreme Court. 65, Lord Justice Moylan then moves on to an apparent reliance on the dissenting overt comments from Lord Sumption, and she goes on halfway through this analysis by this court in Re M cannot have been what was intended by the Supreme Court in confirming that return orders are permitted under the parents' patriae jurisdiction. This would place an unnecessary restriction on the simple order to return or to convey a British citizen in need of protection, which was confirmed by the Supreme Court as being permissible use of the jurisdiction. The difficulty, of course, with all of those arguments we respectfully suggest is that Re M was binding on Justice Lieven and was itself an unappealed authority. So all of this court's observations, in so far as the test and its description of the factors for consideration in terms of context, were matters that fell to bind.
That depends on what you think the ratio of Re M.
There must be circumstances which are sufficiently compelling to require or make it necessary that the court should exercise its jurisdiction in relation to each other. That is, there is then, and my lady is ineluctably leading me into saying that that context and purpose are over to comments by this court.
Well, I was simply asking what the ratio was.
Forgive me.
Give me an answer to that.
But if you're right that is the ratio, then the other observations are simply observations.
They're observations, but observations.
It depends on how you read them.
Of a superior court, which itself undertook, and I'm not going going to tell my lord what Hood did in the judgment of,
Please do.
of this court. But it was a magisterial servant
Oh, yes.
of precedent,
With which the rest of the court agreed.
with which the rest of the court agreed. Of course, yeah. And so when it comes to back to the issue of the weight of such overture comments, that falls, we would respectfully suggest that the.
I mean, speaking directly, Re B raises the prospects that some of the observations in Re M might have been elevated to a status that is not justified.
Yes.
You mean read B or read D?
Re D. What did I say? Re B.
Read
Read D.
which is why
I meant Miss Justice Henke's decision.
Yes, yes. Well, it has been clear from the exchanges of the court with Miller and Friend for the appellant. There is some close textual analysis to engage in relation to Mrs Justice Henke's judgment. But we could anchor, and we were seeking to, at least orally, anchor ourselves more in the realm of Re-M. Clearly, Re-D was cited, there was much exposition in relation to it and debate in front of Mrs.
Well, we have two issues raised. But one is what is the right legal test, but also what is there any error or flaw in Mrs. Justice Lieven's analysis?
Yes.
And the exercise of her discretion or evaluative
Yes.
Jurisdiction. We've been talking a great deal about. We were dealing with the first point. Can you help? If you were to seek to help us on Re D, if you look at Re D, is it? How would you say what would you say the ratio of that decision is?
There is confirmation of the existence of the jurisdiction.
Yes.
But context for the exercise of the jurisdiction is an essential component to the determination of whether or not it should be invoked. Right. And if the purpose or the primary motivator of the exercise of the jurisdiction would be to put the court in a position to make a welfare determination in this jurisdiction, then that would be impermissible or is an example of circumstances in which the jurisdiction should not be exercised.
That's how you would explain her. Was what you say.
Yes.
The rational ratio of her
Yes.
decisions. Thank you.
What about the last words in paragraph 96 and its jurisdictional boundaries?
Well, that's why I use the term close textual analysis, because that, in our respectful submission, is capable of being. I'm just going to draw it up, if I may. I'll give.
Oh, there's something pointed out. She clearly accepts earlier that there is jurisdiction.
She does at the start of paragraph 95 and earlier in the judgment also.
She puts it in terms of the question being should. The start of 95. Should
Yes, exactly. Yes.
The reference to jurisdictional boundaries, to be fair to the judge, should probably be read in that context.
Indeed. Well,
Sorry, I didn't hear what Lady said, but I assume you ignore it. Ignore the phrase. Ignore the words.
I'd say read in the context of what the judge said at the
95.
start of 95.
yeah.
So it doesn't. It's really the statutory scheme.
I perhaps not surprisingly would associate myself with those observations.
You were attacking Miss Kirby's.
No, it's maybe making comments
Have another bash at the.
A critique of this court's judgment. If one move then to how Mr Justice Lieven dealt with
Yes.
this. She, as my lord, my lady has already adverted to, she actually faithfully cites Riem, both in the longer exposition and in the summary at paragraph 55. But paragraph 55, necessarily as a summary, Roman 3, it is a rather bare statement of what we would respectfully suggest were the observations of this court in Riem. So it's the relationship with the Family Law Act and the potential to illegitimately avoid its effect is that summary. That's expanded in the reasoning and discussion part at paragraph 84, which is at page 185.
Yes.
So, having concerned herself with, in effect, the facts and the arising from previous proceedings, present circumstances, and what are repeatedly described as the concerns in relation to the parents and Thailand, she says at 84, I need to be conscious that I am to some extent cutting, specifically having made the decision that she is going to do so, I am cutting across.
Yes.
So she's contemplating this, having arrived at, it appears, a conclusion, rather than considering it as a factor, even an important factor, in whether or not it should be arrived at. There's no other way we'd respectfully suggest. I am cutting across, to some extent, cutting across, as being an indicator that she has concluded that that is what she is going to do, before then going on to say that, having regard, etc., it seems to me that the risk in Thailand must be so manifest that it becomes necessary for her to return for her safety. To that degree, cutting across the statutory scheme seems to me inevitable. We say that there, which represents the high point of the learned judge's engagement with the dicta in relation to context and purpose, is insufficient. It's a scant consideration of an important, not necessarily determinative, but a very important element.
Where does she deal with Mr. Barraclough and Mr. Rees's submissions earlier? Does she make any comment about that in the course of considering the submissions?
She does, because it's in the course of that, I think, that she adverts to the fact that she...
61, is it?
Yes. Yes. And 60...
And Mr. Rees, 63, 64, yes.
And 65.
Yes.
So we were moving on to then submit that the learned judge clearly, from 67 onwards, is engaging in an inquiry in relation to the child's current circumstances and those of the parents in the light of the background. Now, we accept in the light of this court's observations in the case that followed Riem, which was momentarily escaped my mind, in which I think my lord gave the lead judgment.
Yes. Is it another B, is it?
I think it's another B.
Yes, I think it is.
Yeah.
Is it? Oh, no, it's Ries.
I'm not surprised it's
Yes.
it's a minor authority.
Which one interprets as being, in order to determine whether or not the jurisdiction should be exercised, and indeed whether or not there is any cutting across, that there needs to be an examination of the facts and the circumstances in order to determine whether or not there are compelling circumstances requiring its exercise. But the clear purpose of what the judge is engaging in this case from 61 onwards, and the conclusion that she arrives at, that I should return to this jurisdiction, is to put the local authority in a position to make an application under section 31 of the Children Act, and to put the court in a position of undertaking a welfare inquiry to decide who should care for the child. It's exactly the same, we would respectfully suggest, as the form of reasoning that was came for adverse comment by my Lord Justice Moylan, paragraph 137 of Re M. Directly, in those circumstances, we would say avoiding the effect of the 1986 Act, and that would, and did in this case, improperly subvert Parliament's intention, because the main reason for her return is to put the local authority in a position to start care proceedings because of the conclusion that the court has arrived at in relation to her present circumstances. The cases that were referred to by learned friends Kirby, which have already been traversed by learned friend for the appellants, which are on their face examples of the permissible exercise of the jurisdiction, even though there was the possibility of further court intervention was contemplated, don't help her, we say, because Re B, whilst learned friend says that the child's placement in care would have been inevitable, that was not the object. In Re M, whilst care proceedings were contemplated, the purpose was to secure the children's return, I should say, because of a risk to life, Article 2, Mr Justice Mumby, the President, I think he was then, determination. N, D and K was an abduction, the purpose was a return, and in M and U there was another, in fact, Article 2, risk to life, because the child had apostatized from Islam, had received death threats, and it was patent that there was that article, the potential for contravention of the child's Article 2 rights. That's not, none of those elements are this case. I is not in peril of her life. The context and primary object of the exercise, it isn't to safeguard her physical integrity, as in the case of orders made in order to avoid forced marriage or female genital mutilation. This is about putting a court in this country in a position to make a welfare determination, because in the case of a child of this age, at the heart of the exercise of almost any jurisdiction in relation to a baby is going to be the question of care. It's this child's dependence which ineluctably entails the centrality of that issue. So it is at its heart, literally and figuratively, a care case. The question, therefore, that should have been made explicit and grappled with by the judge is, well, that is what this case is about. And the question then is whether these parents can care for her, or someone else should care for her, in Thailand or in the UK. Now, whilst the learned judge expressed great respect for the Thai authorities, paragraph 88, she said simultaneously that it seems to me wrong that I should simply leave I in the hope that she will be protected by the Thai authorities. Why should the parents' decease and limited connection with Thailand reduce the effectiveness of that kingdom's protective powers and jurisdiction? The local authority says in its skeleton, well, the parents cared for I in the absence of any oversight of the Thai authorities, and it was only until the parents returned to this jurisdiction that they became involved. Well, that's right, but why would they become involved? Why would any equivalent body become involved in this country unless they were seized of information that indicated that they should be. What was needed, in our respectful submission, was information from this country which the local authority could have sought permission for to disclose to the Thai authorities, actually at or around the time of I's anticipated birth. They didn't have to wait until June of this year. They knew the due date. They knew that the family was travelling to that country. They could have had the permission, could have sought the permission of the court to disclose it at that point. And with that information, the Thai authorities may or may not have approached matters differently, and there may or may not be judicial oversight if they thought it warranted it. So for those reasons, we say that the learned judge was wrong in saying that the circumstances in this case were so compelling that it required the exercise of the jurisdiction. There were other steps that could have been taken. And in terms of the appraisal of risk, I cannot suggest, of course, that the history in terms of the parents and the findings in relation to other children are not matters that would be of legitimate concern to any tribunal. But the learned judge says that those concerns about I in the parent's care are, quote, not concerns about neglect, but rather ones at the higher end of the spectrum of risk to the child involving drug use, criminality, and domestic abuse. We respectfully suggest that those are not of the same order of risk to life and bodily integrity, which have illustrated the appropriate use, the legitimate use of the jurisdiction in other cases. And there are, regrettably, many care cases in which those issues are prevalent. And if that level of concern, including also parental non-compliance, is sufficient for the exercise of the jurisdiction, it is difficult to see how the threshold for exercising it does not become unacceptably low, and how that is consistent with the, 150 years worth of jurisprudence summarised by Lady Justice Black, as she then was in the Court of Appeal in Re B, emphasising the rarity of the exercise of the jurisdiction and the then extremity of the circumstances which required it. So we say she was wrong. The existence of the jurisdiction is there, but she was wrong to exercise it. In relation to the other matters, as I think I've indicated, we adopt the submissions that were made on behalf of the appellant. May we assist you in that?
No, thank you very much.
Right.
Yes, Ms. Burnell.
Yes, thank you, my lord. The local authority opposes the appeal, and we have set out the reasons for that within our skeleton argument. My lord, perhaps if I can go firstly to the issue of Section 100 of the Children Act, which has already been addressed. My lord, in that respect, we would align ourselves with the submissions that have been made by Mr. Rowley King's counsel, and we submit that there has been no breach in this case of Section 102 of the Children Act by the making of the order made by the learned judge. My lord, we say that it was not an order giving care or control of I to a local authority. It was, we submit, a bare return order. The provisions permitting the social workers to accompany the child back from Thailand were necessary to give effect to that order, not least in circumstances where there are passport orders that would prevent the parents from travelling, even if the court considered that were appropriate, and there being no other person identified or even suggested who who could have accompanied I travelling back to this jurisdiction. The court has already been referred by my lord in relation to section 100 subsection 4 and the local authority could not even seek to invoke the inherent jurisdiction of the grounds for believing there was significant harm. And my lord, perhaps just to expand on the point that has already been made in relation to the observation by Mr Justice Henke appearing counterintuitive from a child protection perspective. The need for compelling circumstances. In our submission, the more compelling those circumstances, and therefore the more likely that the local authority could meet the test as set out in A and B and M in our submission, the more likely, albeit perhaps not inevitable, that public law proceedings would follow. So when we say that there has been no breach of section 100 subsection 2 of the Children Act, my lord raised earlier, or posed the question to my learned friend for the appellant, as to whether there would be anything that prohibited the court making orders that would be effective upon the undertaking of the local authority to issue proceedings and upon the return of the child in this jurisdiction. My lord, in response, was addressed as to whether that would then be a breach of the jurisdictional provisions in relation to habitual residence or presence. My lord, we would entirely agree with the proposition that was being canvassed by my lord, that in fact it would not be improper for the court to take that step if in our submission it followed on from the court's primary determination as to whether or not the inherent jurisdiction ought to be used to order the return. And Lord, we would submit in those circumstances, in fact, the order in which the court is considering those steps is important. But the court would need to consider whether it is ordering a return of the child, making a return order, having made a return order. There would be nothing to stop the court considering the orders that would be needed on return, so once the child was present and upon the application of the local authority. So again, we said that that would be a step in effect implementing the steps that the court had started by using the inherent jurisdiction to order the return of the child to the jurisdiction.
Yes.
My lord, insofar as the 1986 Act is concerned, it is our submission that the order that was made by the learned judge in this case was on all fours with the order that was being considered by the Supreme Court in A. It was an order utilising the inherent jurisdiction. It was a bare return order in our submission. And my lord, of course, in Re B, my lord, I've already been referred to it. The question was posed by Lord Wilson as to whether, I'll just find the right paragraph. Lord, we deal with this at paragraph 21 of our skeleton, page 63. Source for that is page 96 of the authorities bundle. But it's Lord Wilson's reference to the most problematic question arises out of the likelihood that once B was present, pursuant to an order for her return, the appellant would have issued an application for orders relating to care of her or contact with her. Whether in such circumstances an order for her return would improperly have subverted Parliament's intention in enacting the prohibitions in the Act, or in such circumstances should the interests of the child prevail, and indeed would Parliament have so intended? I'll leave it to my Miss Kirby to expand upon the examples if she seeks to do so that she provides within her skeleton argument. But my Lord, if I can briefly address those, because my Lord, the appellant and is really in support of the appeal. They say, well, those authorities don't assist. My Lord, in our submission, they assist to this extent that the fact that there is likely to be, or indeed almost certainly will be, further proceedings once a child has been returned, is not in our submission the bright line that the appellant seeks to argue it is, and that the bright line that means that then the jurisdiction should not be exercised, given that there appears to be agreement across the board that the jurisdiction does exist. My Lord, we submit that there are authorities, and well, certainly there's an authority we haven't included, we haven't referred to it within our skeleton argument, but there has been a marked reluctance, we submit, by the Supreme Court to unnecessarily seek to fetter or restrict the exercise of the inherent jurisdiction. And my Lord, I have in mind in particular Reed T, the 2021 decision of the Supreme Court in relation to deprivation of liberty, which my Lord, I appreciate is in a very different context. But the note of caution being expressed there by Lady Black and the emphasis on the inherent jurisdiction as being the safety net, referred to in one of the other judgments in that case as the ultimate safety net, and the extent to which the court ought to be restricting that inherent residual jurisdiction. My Lord, applying that to the observations we referred to from Lord Wilson, really the final part, the final sentence of the quote we have set out, should the interests of the child prevail, and indeed would Parliament have so intended. Well, the very fact that A and B, the Supreme Court have recognised the continuing existence of the jurisdiction as a protective jurisdiction. And there is, in our submission, a clear emphasis on the protective function. We used that out within our skeleton in Re B, with of course reference to the judgment of Lady Justice Black as she then was in the Court of Appeal in that case, where she placed the emphasis on the protective element of the jurisdiction. My Lord, in terms of where the authorities take us, my Lord, I've been referred to perhaps the criticisms in the Guardian's skeleton in relation to my Lord's decision in Re M. My Lord, we do not make those criticisms. In fact, my Lord, our submission and the way in which we have framed our argument within our skeleton argument is that Re M, my Lord's judgment in that case, in fact, it is not seeking, as we read it, to further restrict the jurisdiction identified in A and B. Well, we deal with that at paragraph 24 of our skeleton argument. That's page 64 of the core bundle. I refer to Lady Justice Black in the Court of Appeal as being in Re B, but in fact, my Lord also refers to that in my Lord's judgment. in terms of the focus being on the protective rather than the custodial aspect of the inherent jurisdiction. My Lord, in our submission, re-M, my Lord's judgment there, again, is entirely focused on the protective element. My Lord, insofar as a test is concerned, my Lord was referred earlier to the observations at paragraph 43, which is 120 in the authorities bundle. But Lord, can I invite the court's attention to paragraph 105 of my Lord's judgment in re-M, which is at page 134 of the authorities bundle.
105.
My Lord, yes, it's at E, on page 134.
Yes.
My Lord, we submit that insofar as a test is concerned, my Lord is encapsulating at paragraph 105 the test that the court must apply, drawn from A and A and the obiter comments in B. My Lord makes it clear there it is not confined to the dire and exceptional, nor the very extreme end of the spectrum, but the circumstances must be sufficiently compelling to require or make it necessary. And if the circumstances are sufficiently compelling, the exercise of the jurisdiction can be justified as being required or necessary, using those words as having the meanings that my Lord had already set out above. And my Lord deals with that at paragraph 101, which is the previous page, 133 through to 102. So, my Lord, that we say, in response to the question raised by my lady, that is the ratio of re-M. My Lord, we say that that doesn't conflict with A or B, but rather perhaps draws the strands together of what had been said in both of those cases. And my Lord has already been referred to, but if I can ask the court to look at, or invite the court to look at paragraph 107, and the observation made over the page at 135 of the bundle, where my Lord deals with the comment made by Lord Sumption in the context of having too low a threshold would increase the prospect of the court making orders which would cut across the statutory scheme. My Lord there goes on to say, it's halfway between A and B, this can of course apply whenever the jurisdiction is exercised, but it provides an additional reason for limiting the exercise of the jurisdiction to compelling circumstances. My Lord, on reading that, it appears to us to suggest that there may well be circumstances, and this is perhaps the bright, coming back to the bright line point again, where the order may cut across the statutory scheme. I'll come back to that phrase in a moment. But actually, that cutting across, or even if it is to a limited extent, can be justified because of the compelling circumstances, we would add to that, in the exercise of the court's protective jurisdiction in relation to a child. My Lord asked earlier what was meant by cutting across the statutory scheme. And my Lord, that is something that rather troubled us to a certain extent, because at one end of the spectrum we have, perhaps cutting across the statutory scheme, a court making an order that appears to be in direct contravention of a statutory provision. I suspect we have a little difficulty with saying that that is an example of cutting across the statutory scheme. At the other end of the spectrum, we may have
That would also be a jurisdictional problem.
and a jurisdictional problem, of course, yes, my lady. We would then have at the other end of the scheme the use of the inherent jurisdiction to fill in the gaps where there isn't any provision within the statutory scheme. And then there is something, perhaps, it is something of a spectrum in between that. But if we start to then take into consideration whether it cuts across the statutory scheme, not because the order on the face of it conflicts with any statutory provision, but because what might happen next, as far as the issue of proceedings is concerned, had any application been made, which of course there wouldn't have been jurisdiction for, that in and of itself would have been a cutting across the statutory scheme, and there wouldn't have been jurisdiction to make such an application had the return order not been made.
So that might lead to a submission that the expression cutting across or cuts across the statutory scheme is not very helpful, because it somewhat might lead to confusion.
My lord, yes, because is there a point at which there will almost inevitably be some cutting across of the statutory scheme, which of course the learned judge herself recognised in the present case.
Well, it is the difficulty treating it as effectively a bright line test. You must not cut across the statutory scheme. If it is trying to look at your sort of grey spectrum in the middle of your two extremes, it might be a factor. In fact, I think this is what Rayanne may say. It might be a factor that you should think about. The judge should be weighing that up.
And that's what Mrs Justice Lieven thought.
Yes, I'm not sure I accept the submission made earlier that she'd already made her mind up. That's the way the judgment was expressed. She clearly thought about whether this was cutting across the statutory scheme as a relevant factor. Why else put it in her judgment if it wasn't? But maybe it's no more than that, something that you have to think about in determining whether this is a case in which you should exercise the jurisdiction.
My lady, yes, we would entirely respectfully agree that it is something that the court would need to consider. And my lady, we say that is a direct application, in fact, of what my lord said in Re M, because, and my lady, at paragraph 107 at the top of page 135, it's the point we had already referred the court to. My lord acknowledged that it might apply whenever the jurisdiction is exercised, but it provides an additional reason for limiting the exercise. So it's a reinforcement, as it were.
One of the reasons for exercise, or one of the factors to take into account in deciding how you exercise, whether you exercise the jurisdiction.
Yes, and a useful reminder of the exceptional circumstances or the relatively high test that is to have developed from A, B and M as to whether or not the court should exercise its jurisdiction when my lord talks of compelling circumstances before exercising the jurisdiction. So my lady, we say it's certainly relevant in that context when looking for those compelling circumstances. It's a reminder as to why those circumstances need to be compelling in the particular case. My lady's raised it, if I can deal with it very briefly, in relation to the point taken as to whether or not the learned judge had made up her mind. My lady, can we also refer the court, invite the court to consider paragraph 50 of the learned judge's judgment. That's at page 178 of the core bundle. So it's not simply that it appears at the end of the judgment her having made the decision to make the return order, where she, paragraph 50 is where she is dealing with the law, the legal framework that she must apply, and within that section, before moving on to her analysis, she discusses there the cutting across of the Act, but states that the Supreme Court, however, says that the jurisdiction continues to exist. So, my lady, we would submit that the learned judge had that firmly in mind throughout her decision-making process.
because you referred us earlier to what Lord Wilson said, and his, I know then he was just putting point and counterpoint in one respect of one feature, but he wasn't saying cut across. He's said improperly has subverted Parliament's intention in enacting the prohibitions. So is that the same as cutting across, or is there a difference? So I'm getting rather over analytical now, perhaps.
Oh, I think it depends on what meaning we give to cutting across.
Yes.
Subverting perhaps might actually be a clearer definition. Is there an attempt to go behind what Parliament intended in the statutory provisions? We submit the Supreme Court, having left open this and being clear that inherent jurisdiction continues to exist,
Yes.
is clear authority and binding authority on this court, of course, that it exists, and in and of itself, it is not a subversion of
Yes.
the parliamentary intention.
Yes.
That it exists alongside the statutory scheme,
Yes.
and as it were fills those gaps for children who would not otherwise be protected. I referred to.
And you might, I mean, in a sense, the existence of one of the factors referred to by Lady Hale, namely the reciprocal international provisions, is rather random. It entirely depends on what states have ratified or acceded to the convention. So that wouldn't be I mean, it's slightly arbitrary, has slightly an arbitrary effect if the consequence of another jurisdiction not having ratified the convention is said to have such a significant effect on the manner in which we exercise our inherent jurisdiction.
My lord, yes. And of course, my lord in Rien deals with those three factors that were identified by Baroness Hale and Lord Torson. My lord deals with that at page 74 of the authorities bundle. We've dealt with this in our argument in paragraph 24, which is page 64. But my lord treats those three reasons rather as general reasons, that rather than providing a test or a guide.
Sorry, where does my lord deal with them? Oh, it may be para 106.
Maybe, forgive me, I have given a completely wrong reference. Maybe page 127 of the authorities bundle.
I'm sorry, which paragraph number was for now?
Forgive me.
The three reasons are set out in a quote within paragraph 77 of my lord's judgment.
Yes.
I'm very grateful to my friend. Page 134, paragraph 105. I've also noted down completely incorrect reference in my notes, and I apologise.
I think it's mostly.
So I think it's paragraph 94, page 132. I apologise for getting so many different references. Yes, it is. It's paragraph 94, page 132 of the authorities bundle. My lord says they will not be put forward as providing a test or a guide There were general reasons for explaining why the court should take a cautious approach. My lady, reading those reasons that are set out by Baroness Hale and Lord Tolson, that must be right, because they don't describe it as being a test. And not only that, maybe Baroness Hale and Lord Tolson say, in fact, those three factors have little relevance in that case, so they identify them as reasons for exercising a circumspection or caution, but say actually, in and of themselves, those three reasons were not particularly relevant to that case. If I can return again to Re M, my lord, in that case, makes clear in the judgment, when dealing with the bright line point, that the decision was, of course, based on, as indeed it must be, the facts of that case. And whilst much the argument has been taken up with what is said in relation to jurisdiction, of course, my lord, there were other allied criticisms of the approach the judge had taken at first instance and the evidence that had or had not been taken into consideration. And my lord, our reading of Re M suggested it was all of those matters that leads to the overall decision in that case. And I would again, perhaps another part of the ratio from that decision in Re M was the need to consider all of the circumstances of the case. Well, we have accepted within our skeleton argument that the local authority's intention to issue proceedings, if a child were to be ordered to, an order was to be made ordering the return of a child to this jurisdiction, would be one of the factors or matters that the court ought properly to take into consideration, in part because of the question posed by my lady earlier as to whether it's going to cut across the statutory scheme, but also when surveying the overall picture for the child. Because, my lord, in Re M, of course, there was the criticism that the judge at first instance had not had sufficient evidence or information available to him to have made or to have reached some of the conclusions he had in relation to the child's welfare. And the impact on the child of the proposed care arrangements upon return. Of course, bearing in mind that was a child who was still in the care of a parent in the other jurisdiction, unlike the present case. Well, we have referred to the decision of this court in Re S. And we have quoted what my Lord Justice Baker said at paragraph 52, that's at page 164. I say that with great regret, hoping my reference is correct. It is paragraph 52 at page 164, emphasising there the need to guard against the inherent jurisdiction being used improperly to circumvent statutory limitations. It must be limited to compelling circumstances, but it does not obviate the need for an assessment of the circumstances to establish whether they are sufficiently compelling to require the court's exercise of its protective jurisdiction. My Lord, taking those authorities together, we submit that the learned judge had all of those authorities firmly in mind when she then embarked upon what we say was a proper analysis of the factors and matters in this case, setting out both those factors which in her view would support the making of an order and those which had to be weighed in the balance against the making of an order in this case. And I will resubmit that her decision making on that issue was entirely proper, and she reached a conclusion which she was unable to, which was an entirely permissible one on the basis of the information before her, on the basis of facts that are largely agreed and accepted. The court, of course, has been referred to other authorities and the nature of the harm or the risk that the court has been concerned with in those cases. But Lord, we submit, we included this within our Scantron argument, that there is no defined category of risk. Category or categories of risk. It has to be, in our submission, case specific and on an analysis of all of the relevant facts. And we'll resubmit that. That is clear that that was the approach taken by the learned judge, and from her observation that it was only if the risk in Thailand was so manifest that it was necessary to order I's return that she should do so. This court's already been addressed on whether it is being suggested that the intention of a local authority to issue proceedings provides that bright line. We submit it does not. We have set out what we say are the compelling circumstances that the judge was entitled to rely upon at paragraph 43, page 70 of the core bundle. It's suggested that this is, in many ways, an ordinary care case. In our submission, the mere fact that the factual circumstances presented here may arise in other cases does not in and of itself mean that the reasons for ordering I's return were not compelling. It is also clear that the learned judge doesn't elevate any one of the circumstances improperly, but rather takes a holistic view of all of the circumstances. And we submit those were compelling. As set out, we have a vulnerable young baby, then just aged 7.5 months. Her dependency is one compelling factor. The fact that she is without anybody exercising parental responsibility for her and is placed in what we have said is effectively institutional care during the week. And not able to form the appropriate, age-appropriate attachments and bonds that one might expect for a child of this age is compelling. And we submit it was entirely appropriate for the judge to take into consideration in her assessment of the circumstances the continuing lack of clarity and uncertainty around the arrangements for I will pose the question earlier, well, what if the parents were unable to get a visa? That has to be a real consideration in the present case.
Whether they could get one, or what would happen if they did, or both.
Both, my lord. The fact is we simply don't know. The lengths to which the parents had gone to evade professional involvement. The learned judge expresses she has some sympathy for how the parents may have felt in light of the history of professional involvement. That they not only travelled abroad to evade local authority involvement, something which they both acknowledge when they speak with the police, but there had been continuing dishonesty as to whether or not a child had been born, references to miscarriages, references to I being their first child, rather than in fact the mother's seventh. Those are all relevant matters we submit that the judge was entirely correct to weigh in her assessment. As well as the position of the Thai authorities. We know, it is clear, the Thai authorities are not seeking, certainly thus far, have not sought to argue that the child ought in fact to remain in Thailand. She is not a Thai national. The birth certificate makes that clear. A copy of the birth certificate, from all the references at page 274 of the report.
Well, at the moment, she probably has no right to be there.
I would know that the parents' understanding is, having been born in Thailand, she can remain. She does not need a visa.
Right,
but
okay.
if she left,
She wouldn't come back,
then
wouldn't be
need a
allowed
visa
back.
to get
Okay,
back in.
thank you.
So that is certainly the case, as I understand it, advanced by both
Yeah.
the parents as to their understanding of her position.
But certainly the point you're making is the Thai authorities have indicated that they don't seek to obtain guardianship, and there's no indication at the moment, indeed, they have there's any sort of expectation that they will bring any form of proceedings.
My lord, that's entirely correct. My lord, the reference in the papers to them having undertaken visits, my lord, as you understand it, there have been 2 visits, but there's one at the start of July. Appears from correspondence there is a second,
Yes.
the date of which just isn't
Yes.
given, but it provided some photographs of the child.
Thank
So
you.
there's very limited involvement from the Thai authorities, and all correspondence from the Thai authorities has been entirely cooperative insofar as the proposed return of I, as far as they will assist with transporting her to the airport and handing her over. Really to the extent of asking when is this happening,
Yes.
as opposed to in any way seeking to stand in the way of it. My lord, there is reference in the appellant's skeleton argument that, well, if the parents were to return to Thailand, if the orders were discharged and the parents were to return, the Thai authorities would have to review the situation. Well, that was the assumption of the FCDO. That is not an indication from the Thai authorities at this stage, albeit one would hope that they would do so. My lord made the observation earlier that it's rather akin to, perhaps akin to, a request for the transfer were it a convention country. That appears to be entirely the approach that's been taken, and the approach that's been taken by the Thai authorities with no opposition to the proposed course of action. So whilst some reliance is placed by the appellants on the observations that have been made of eyes showing a child who is appropriately and well cared for and having her needs met, those observations have been made since the parents left. They're not observations of her in the care of her parents. The observations that the court has are really limited to her not unimportant physical care and well-being. But we submit that it's inevitable emotional harm caused by her being in institutional care during the week cared for by friends of the parents at the weekend, and without a parental figure with whom she can be forming important bonds and attachments at this crucial stage of her development, is something that the observations in and of themselves simply can't address, and something which we say is almost inarguable insofar as the harm that she is likely to be suffering is concerned. My Lord, when we deal with the decision made by Mr Justice Hayden in ND and K, my Lord, we've referred in our skeleton to an observation that he makes at page 225 to 226 of the authorities bundle, at his paragraph 27, where he reminds us again that the exercise of the jurisdiction requires extreme circumspection, confined to broadly protected purposes. But he says this: the court must therefore ask itself whether to do so would be to work in harmony with related foreign laws, so that together we can more effectively achieve common objectives in an expansive spirit of international comity. Well, in our submission, the orders made by the judge and the approach of the Thai authorities do just that in the present case. And I look at the exercise of the jurisdiction that was required in this case as being the only means by which I could be properly protected.
Yes.
I was about to say, can I assist on any other matters? And the bell chimed.
Anything else? No. Anything else?
Strikes.
Absolutely, yeah.
So we'll start again at 2:15. Thank you.